we begin, I must share with all the members of the bar that we are very honored to have in our midst Justice Antonio Herman Benjamin, a very distinguished scholar and international judge from Brazil. He's due to be sworn in as the Chief Justice on the 22nd of August this year. We're very privileged to have Justice Antonio with us. He's a great friend of India, one of the foremost international experts on the law relating to the environment. So he's just come back from a trip to Srinagar, Sonmarg, Kargil, Leh, and back. So he drove all the way. He's very fond of India, and we're just sharing with the colleagues what his experiences about that trip. So we welcome you in our midst.
On behalf of the bar also, my lord, I welcome the honorable guest to this.
Thank you. So we'll start with our daily board.
Lord, may I just mention, I have circulated a mail. The reason is, my lord, I mentioned it before vacation. Lordship said it will be listed. It was not listed because it's an old matter. Regarding a PJI admission matter, my lord.
All right, I'll list it, yes.
My lord.
Lordship, may I mention?
Just circulate an email and I'll attend to it in the afternoon today. Just circulate an email and I'll get your matter listed as quickly as possible. All right, let's see the first day.
My lord, may I mention item 40? My lord, by the time the matter reaches on board, my lord, NTA can be directed to produce the original OMR of the
Nothing of this sort, wait for the matter to reach. Yes, item 1.
May I please, my lord? In item 1, this is a bail plea, my lord. The petitioner is in custody since 10th of February 2022.
In possession, you were alleged to be in possession of 80 kilograms
I
of
was
coffee.
not found on the location, my lord.
You are not. They say that your identity cards were found in the vehicle.
No
You're
responding
not
to the identity card, my lord.
You're not the registered owner of the
I'm not the registered. I have placed it on record, my lord. The registered owner says in his cross-examination, he has been cross-examined.
allegation is that the vehicle has been transferred in your favor.
He says, but in the cross-examination, he says he cannot confirm if the vehicle that has been alleged to be found by the police is the same vehicle which he sold to me, even otherwise, my lords.
All right, we'll issue notice here and keep it after 2 weeks. Serve the standing counsel for the state of Madhya Pradesh.
I'm most grateful.
Issue notice, returnable on liberty to serve the standing counsel for the state of Madhya Pradesh. You have been denied, Antonio.
I'm most grateful, my lord.
Item 2.
Very short question is what
There's a delay of 235 days.
There is a delay, my lord, because
Why should we condone the delay?
My lord, there was.
And look at it this way. When they first filed their claim before the tribunal in Madhya Pradesh, you objected to the jurisdiction of the tribunals, relying upon the judgment in VA Tech. True, the judgment in VA Tech has been overruled subsequently. But at that stage, at your behest, he was sent to the arbitrator. You didn't object to his jurisdiction before the arbitrator.
By the Honorable High
Right. But then you never objected before the arbitrator. Now there's an award.
It's a matter of record that we objected only at the stage of 37, my lord. I cannot quarrel with that.
We'll dismiss it. What we'll do is we'll dismiss it on the ground of limitation, so that it doesn't become a precedent in any other case. And we'll keep the question of law open. There's a delay of 235 days in filing the special petition against the judgment of the Madhya Pradesh High Court dated 9 December 2022. Full stop. There is no satisfactory explanation for the delay. Full stop. Hence, the petition is dismissed on the ground of delay. However, we clarify that since the bar of limitation has intervened, it has not become necessary for this court to express any opinion on the question of law raised.
It will remain open, my lord.
Which is kept open. We shouldn't say it's open because actually the question of law is decided in your favor by our judgment of 2018. Because the judgment in VA Tech has been overruled by our court.
That is
so if we keep it open, we are tacitly then casting doubt on our judgment. The question of law is in your favor. Just that we are not interfering in this case.
At this stage, my lord, if I may only.
I will say it's kept. The question of law is kept open. Fair enough. You wanted, we'll give it to you.
I'm very grateful, ma'am.
Please, my lords.
My lords, this petition has become infructuous because subsequent developments have taken.
Counsel appearing on behalf of the petitioner states that the petition has been rendered infructuous by subsequent developments.
I'm sorry. I want the question of the law to remain open, my lords. simply being, my lords, because this was the second petition, my lords, pursuant to a settlement agreement.
That's all
And
right.
lordship's court
It's
has,
always open quas. Nothing
Lord.
is concluded by us. We're just saying that it's infructuous. Item 4.
my lords, it will ultimately, the matter will ultimately be the lordship's court only. So I'm just.
So it's always open quas. We are saying it's disposed of as infructuous. It can never bind on a future bench.
I'm very grateful, my lords.
In this matter, admittedly, the NCLT finds that my claim and my allotment to the flat is reflected in the information memorandum, which is the basis of any resolution plan. And it is showing in the record.
What about delay?
Yes, my lords. On delay, my lords, admittedly, I am not present when this pronouncement is made. My lords, the matter is reserved 3 months back. It comes in a pronouncement, my lords. My appearance is not there. I have vehemently said that I was not present. It is uploaded, my lords, and
What is the date on which it is uploaded?
my lords, it is uploaded on 22nd of August 23, from which, my lords, I am within limitation, excluding the certified.
You were not
copy.
present. Were you a party?
Yes, it was my application, my lords. On my application while reserving.
But then if it's your application,
Yes, my lords.
then can you say that I was not present? I don't know because.
So, my lords, the arguments happened. The order stands reserved.
But it is,
It's not
when is the order pronounced actually? It's not pronounced at all.
Not on the dates argued, my lords, not on the dates heard. It comes up in the list 3 months after for pronouncement.
22nd August.
No, my lords, 11th of August. 22nd August is when it is uploaded and which is when I gain knowledge of the order. And I, my lords, file immediately. I file the appeal immediately.
Learned counsel appearing on behalf of the appellant submits that that in the application which was filed by the appellant, though the order was passed by the National Company Law Tribunal on 11 August 2023.
Yes.
The order was uploaded only on 22 August 2023. Hence, it has been urged that the appeal which was filed on
The appeal was
October 2023.
my lords, 10th October 23.
10 October 2023 would be within the period of limitation of
My lords, 61-2.
the limitation. We'll issue notice,
Great.
returnable on.
My lords, may I only make one request? The resolution plan basis which my application was dismissed even to date has not been approved by the NCLT. Now, my lords, may I only request for an interim stay until.
We'll make it returnable in 2 weeks. Why
Grateful.
stay everything? Serve Dusty and come.
So good.
See, in this case, the NABARD, though initially it said that there may be certain irregularities in the functioning of the bank, subsequently it filed an affidavit before the High Court stating that the resolution of the board was proper and that there were no irregularities. Ultimately, this was a public interest litigation. You brought some grievance to the attention of the court. The court has felt that it is not necessary to interfere.
Page 368 may be seen for a moment.
What is that?
Ordered by High Court, Honorable High Court.
The earlier High Court, the earlier order.
Yes, my lord. It says, my lord, pursuant to previous order, action taken, report on behalf of the NABARD has been placed on record. Prima facie, certain allegations were stated to be true.
But that is prima facie. Subsequently, NABARD files an affidavit and says that we have now looked at it and there's nothing.
Later, my lord.
Anyway, as a PIL petitioner, your duty was to point it out to the High
Yes,
Court.
Lord.
High Court went into it. NABARD is a national bank for rural development. They file an affidavit. Now, why should we?
But the error is page 389 may be seen, my lord. Uttar Bihar Gramin Bank, as well as, my lord, the sponsored bank, Central Bank of India, was directed to take decision on this erroneous, my lord, activity. But that is my.
But look, ultimately, as a bank, it is regulated by the state authorities, since it's a state bank, as well as to a certain extent by the Reserve Bank of India. Why should we presume that they will not look into the any regulatory failures in the bank?
Lord, may I submit, Lord, any fraud above 3 crores, Lord, is directed to be investigated by CBI. But here the quantum is not above more than not 500 crores. That is
Sir Counsel, we are referring to the affidavit filed by NABARD dated 21st February 2024, where the averment is that it is humbly submitted that as per the specific directions dated 18 January 2024 of this court, the instances pointed out in the special audit report were scrutinized. On scrutiny, respondent number 4 is satisfied with the resolution of the board of UBGB that the guidelines of fraud are not applicable to the present matter, audit report, and therefore the matter is not required to be referred to local police / CBI as per clause 9.1 and 9.2 of respondent number 4.
initially not 13.
I think we made our point clear. I think we'll not entertain it further. It is a PIL after all. Yes, dismissed. Item 6.
Okay.
Item 6. Yes, Mr. Raghunath, you are on the screen.
Advocate Raghunath on the part of, on behalf of.
Filed a writ petition before the High Court for early hearing of your appeal before the DRAT. And now you are in the Supreme Court under 136. We're not going to entertain these kind of.
Your Honor, my lord, the test will be against the order of the Honorable High Court, and there is no supervisor. There is no, about 24 hearings have happened.
What do we do? The tribunals are, it's not that the tribunals don't have work. They have their own priority.
But my lord, it's a question of recovery of 208 crore to
I
be.
know, but you are postulating that your case is the most important to be reaching the line or the queue. Other cases may be as important before the tribunal. Why should we expedite your case? We'll not do anything like that. Thank you. Dismissed.
Well, this is a petition seeking appointment of an arbitrator. The clause of arbitration which finds place in the SPA was SHA, which was initially disputed by the other side, gradually accepted on an affidavit and recorded by the High Court in its order, saying that they were trying to mislead the court, but they've then accepted the existence of the SHA and the arbitration clause. We are only seeking appointment of an arbitrator because one of the respondents is a Sri Lankan citizen and the other is an Indian citizen, both of them being shareholders in the company, which was created pursuant to the SHA.
My lords, I'm appearing for the respondents hearing. Let them supply me a copy. I'll come back in 2 weeks and give my no objection for the appointment.
For the appointment of the arbitrator?
Yes. My lords, after perusing the agreement, because there was a confusion about the agreement per se, the notice of invocation says the arbitrator.
Fair enough. You're appearing for both the respondents, right? You're appearing for both the respondents.
Yes.
Fair enough.
Well, they have admitted the existence of
He
the.
doesn't have a copy of the papers. He's on caveat. So
I'm not on caveat also. I'm just appearing.
Issue notice. Mr. Can I have your name?
Karthik Malhotra.
Mr. Karthik Malhotra, then counsel appearing on behalf of the states that he has instructions to appear on behalf of the respondents, and seeks a short adjournment to take instructions. A copy of the paper book be supplied in the electronic form to the Senate Council for the respondents. List on. Should we keep it on Monday and finish it on Monday?
Please, my lords.
My lords, Friday.
All right, next Friday.
Next Friday.
Very good. Next.
Yeah. Item number 8.
My lords.
The candidate who was selected as the president of the Consumer Disputes Redressal Commission for Mallarkotla,
Sangrur.
as for Sangrur. The candidate who was selected resigned
Within 6 months.
within 6 months, in which case you are the second candidate. You have no vested right for appointment. If the candidate does not accept the appointment, then the second candidate can say that, well, appoint me to the post. Once a candidate is appointed, then the select list comes to an end because the process is complete.
Was only this, Lord, that the OM says that if a person joins and resigns or vacates within 1 year, then, my lord, the merit list has to follow. In this case, my lord, the OM is there, and the judgment of my lordship, 3 judges of this court have said, and my lords, this is since no, that's right, my lord. But my contention is that since this is a judicial selection, instead of going through a fresh selection process, my lord, people can, and I'm there in the merit, my lords.
The government picked out all candidates who are lower in the list. That whole selection process in Punjab was replete with all kinds of
What they have
difficulties.
done is, in my district, Sangrur, after my lord,
Because the Punjab government thought that they can just pick up candidates who, are, suitable to them, overlooking the select list.
so that's my case. When one resigned, they appointed someone who was not even in the list, who didn't even apply. I was there at number 2. They
But
didn't call
see,
me.
his appointment may be invalid, but
So
he has no vested rights.
So here, he's R5, my lords, he's R5 here. I said so in my LPA. When the writ was pending before the Honorable Single Judge,
Whom did they appoint?
they appointed one Jot Karan, who was not even in the select list.
No,
Page
but look at
70 is the select list.
But look at it this way.
Yes, my lord.
Your plea was appoint you. You're not really concerned about his appointment.
In the writ petition, it was appoint me. When the judgment is reserved in the writ petition, on that day, they appoint this person. I filed an LPA. I said, how can you appoint him? You have to appoint me. The OM is there in my favor. The 3 judges is in my favor.
Did you ever challenge his appointment?
In the LPA. Because in the writ petition, he was not appointed. He was appointed on the day when the judgment in the writ petition was reserved. So I could not have made him a party in the writ petition. I made him immediately in the LPA. I made him immediately in the LPA. I made an application, and he's R5 here before your lordships. A person who is not selected is working, my lord, as a presiding officer of the Consumer Forum, and I was there in the merit list. As in the wait panel. OM says, my lords, the panel.
Petitioner, the grievance of the petitioner is that the candidate who was first in the select list, right?
Very well.
The candidate who was first in the select list for appointment to the post of president of the Consumer Disputes Redressal Commission, Sangrur, resigned. Full stop. Thereafter, full stop. The petitioner was second in the select list. Full stop. According to the learned counsel, after the judgment was reserved by the single judge,
yes,
and before it was delivered,
yes,
the 5th respondent was appointed
yes,
as the president
yes,
of the District Consumer Disputes Redressal Forum, though he was lower.
He was not in
though he was not in the merit list at all. Full stop. The petitioner has been non-suited on the ground that once the first candidate, was it a fresh appointment then? They just picked him up without
Picked him up without him.
All right, we have recorded your submission. The grievance of the petitioner, therefore, is that even if he was not eligible to be appointed as district, the grievance of the petitioner is that the selection of the 5th respondent is completely contrary to law, since his name did not figure in the merit list at all. Full stop. Issue notice returnable on after 2 weeks. Thus the permitted in addition. Liberty to serve the standing counsel for the state of Punjab in addition. You have come here after 280 days delay.
Father passed away during this period. Father was very serious.
280 days is too much. And on interest, claim is on interest in addition to the return of compensation.
I invite your lordship's kind attention that page 9. It has been recognized. It has
What's
been
the point?
approved. Yes.
What's the point that you want to make?
Well, it has been approved. It has been said that yes, this due is there.
You have to open that. To open the door, you have to first get the delay condoned.
My father passed away. I have said so. And he was bedridden, and
there's a delay of 280 days in filing the special petition, for which there's no satisfactory explanation. Full stop. The petition is dismissed on the ground of limitation.
I circulated a note yesterday evening.
Yes.
My point is that it's a statutory violation has been under remedy.
Tell us one thing. After the conciliation proceedings failed before the Facilitation Council, you have said that they never called upon you to file a statement of claim.
No statement of, I was a defendant, so no statement of claim is filed, no evidence, nothing. Just that the initial claim form which is filed before the MSME, which is a unrecent, just 1 page of form, On that basis, only the ultimate order is
You
passed.
get to file your statement of defense.
We did get to file those. We got to file those. But the conciliation, how it failed was that the first day I show up without the wakalatnama, that day itself, the other side prefers an application, already pre-drafted application. And on that basis of the application, same day, immediately the order is passed, there's no conciliation possible, let's move. But section 65 of the Arbitration Conciliation Act says, mandatorily, both sides have to be called upon to file the written responses, and that conciliation has to happen in good faith. Even UK law and all, they have gone on to that level where they say that good faith.
Assuming that conciliation failed, thereafter what happened before the
No conciliation happened. Then I was called upon to file my defense. I filed. Then arguments reserved. Some fellow, Mr. RK, heard the arguments. The ultimate award is passed by some other 3 people who have not even heard the matter. So RK is the signatures on the
You've come here against which order?
Well, I've come again the order passed by the division bench of the High Court saying my 34 is not maintainable. 34 I should have gone on 34. Writ petition is not maintainable.
But you have a remedy under 34, right?
Well, I won't have a remedy under 34 because section 65 violations of the Arbitration Conciliation Act are not palatable under 34 grounds.
No, but what you are aggrieved by finally is the award.
Well, I've tried to draw a distinction from that India Glycos judgment, which is falling from my lord. I'm conscious of that. There's a Jharkhand Urja judgment in my favor, which says if the mandatory statutory violations have taken place, then writ petition is maintainable vis-a-vis the MSME Act. Squarely covers my case. Number 2, my lords, the India Glycos judgment and other judgments which my lords have held, those are cases where people were trying to make their cases on merits of the case. I am not on merits at all. I'm on the violations of the MSME Act. And I'm trying to portray my case there, my lords. So my humble submission is basic structure 226, etc., will be attracted when statutory violations have taken place. If it was a case on in fact,
Problem is that you are yourself saying that you're not challenging it on merits, but only on statutory violations.
the merits grounds are also there. I'm saying for the statutory
merits which you raised was that that they were not registered as a micro MSME on the date of the agreement. So there's a finding of fact concurrently that they were registered.
No, what has happened is those merits arguments are also there, but to distinguish my case from the previous judgments, that's why I'm trying to portray my cases there.
Sold, supplied, and delivered. You have not paid them.
No, my lords. That's not the case at all. My lords. The case, my statement of defense is not on record. My apologies on that. Right. But what if the transaction is slightly different?
Balance of the principal amount of 24.82 lakhs was not paid.
My lords, I'm ready to deposit the principal amount. That's no difficulty at all. But the point is, my lords, my defense could not be brought on record because there's no procedure that has happened. There's no basic arbitration and conciliation norms that have been followed. In fact, my lords, there's one Delhi High Court judgment which says if it shocks the conscience of the judge, then the writ petition is maintainable, even against MSME matters.
In a petition under section 34, all these grounds, suppose in an arbitration, forget the MSME Act, arbitrator doesn't hear the defendant and passes an award. Is that not amenable to a 34 application?
I bought on my lords. The mandatory provisions of Arbitration Act not followed, ground under 34, absolutely correct, my lords. But my lords, this is under the conciliation process of section 65 violations. So they may not be fall under the 34 minutes. And besides, my lord, one person hearing the matter, other person passing the award, who I don't even know.
But why did you not choose to challenge the award under section 34? All these grounds are available. That's your ground is a violation of public policy.
I'm only saying, my lords, that under the Jharkhand Urja matter, I'm squarely covered, my lords.
Thereafter, it becomes an executable decree, right?
May I say this, my lords?
For the writ is that you don't have to deposit.
May I say this, my lords? The Jharkhand Urja judgment which covers me is of 2021. My lord's judgment is of 2023.
Leave it open to you pursue your remedies under section 34.
I'm so grateful, my lords.
The petitioner had an efficacious remedy of challenging the award of the Facilitation Council under the MSME Act by taking recourse to the provisions of section 34(2) of the Arbitration and Conciliation Act 1996. This was the matter, the High Court was justified in declining to entertain the writ petition under Article 226 of the Constitution. Hence, we are of the considered view that the grievances which are sought to be raised in these proceedings can be addressed in a petition under Section 34. Full stop. Any observations by the High Court on the merits in the impugned order shall not stand in the way of the petitioner taking recourse to the remedies to challenge the arbitral award.
I'll be hit by delay, Milos, because now.
But you can say you were bona fide pursuing your remedies before the High Court. What else can we say?
Milos,
You can't condone the delay, which is beyond now the 90 days.
Milos, that's there, Milos, but that will be rendered me, Milos. It's a good case on merits, Milos. Milos have seen what has happened in this case, Milos. In fact, Milos.
We have vested right in yours to their benefit. How can we obviate a limit set by Parliament?
Milos, I understand that, Milos.
Then really speaking, if it's barred by limitation, you should just dismiss it. Otherwise, your client will spend another round of.
No, Milos, but Milos give me liberty, Milos will not fructify to my interest if the debt delay aspect is not covered.
All right. But we'll not condone the delay here. You have to move.
Milos may only observe that I may permit it to raise these points. That will be, Milos.
You can always say that condone the, but we can't, because there's a maximum period which can be, which is condonable. We can't go beyond that, like the IBC, the Arbitration Act. Condone the delay of 36 days in filing the SLP. There's no difficulty there. Then you can say I was pursuing my remedies bona fide before the Supreme Court.
I'm in Milos' hands, Milos.
Condone.
Item 11.
Question sets aside, my lord, the well-reasoned decree and the judgment of the trial court. Para 15, my lord, it proceeds to record a wrong date, contrary to what has been pleaded by the plaintiff himself. And then my lord says that we were at fault in not pinpointing it promptly. My lord, three things were missing from the impugned judgment. If your lordships may please see, my lord, page 1.
You paid them 90% of the payment.
That's right.
Right?
Right.
So the dispute was only in regard to the balance 10%.
Lordship, please.
So the High Court says first, the very fact that you paid 90% shows that the work was being executed. Now, question is still, I mean, you may still have a point that, there were delays or deficiencies on the part of the respondent. Where did you raise the issue of delays or deficiencies?
No, my lord. We have said so in the written statement, coupled with the fact, my lord, there is a finding of fact that the work completed was only to the extent of 90%. And therefore, my lord, the learned trial court held this, my lord. Please have a look at page 175.
So what evidence did you produce to establish that there were delays late?
Yes, sir. 30th of next year, P11, your lordships may see. Or my lord, lordships may please have an next year P12. Now, this letter, which we have pointed out, my lord, on 30th November 2012, the judgment in question says that you...
But tell us what is the evidence which you laid?
My lord, this was one of the letters, my lord, 30th November, and the rejection letters at document P11. Kindly just see, my lord, next year P11 from pages 102.
You had to prove your defense that there were delays and that there were delays or deficiencies by adducing the evidence of a person cognizant of the contract which was being performed, and then establish, by producing documentary material that, well, there was a shortage of work or there was measurement carried out which resulted in,
Lord, if I may say so with respect, my lord, the next year P11 pages 102 to 115 were the rejection notes. Then, my lord, the chairman of the company appeared as DW1. And then, my lord, 30th November 2012 letter, which was within the warranty period, but not considered by the judgment in question, that has been set aside, my lord, on the premise that the work was completed in July 2011. But the plaintiff himself says that it was in 2012. Para 19, if I may just draw your lordship's kind attention, please have a look, my lord, at para 19, page 187. That is, my lord, the fundamental error, my lord, in the judgment. Besides the point, my lord, that para 19.
Ultimately, you are here under 136.
I know, my lord.
That's the problem.
My lord, only two respectful submissions. First and the foremost, my lord, the evidence, etc., my lord, even the bills which were presented. The learned trial court has held that these were not actually the bills which were submitted or ought to have been submitted. They have not been proved. Then, my lord, there is a heavy discrepancy on my pointing out the deficiencies, because the High Court says, my lord,
it's purely a matter of appreciation of evidence in our case. Thank you.
Right.
This has to be tagged. This has to be tagged. Ganpati deal.
This has to be tagged.
Benami.
But kindly see the tribunal's order for a minute. It's PDF.
You are appearing for?
Well, I'm on caveat. I don't know the
We've got other matters which are pending, so we'll.
Well, kindly see, because ultimately the tribunal, I had gone in appeal. The tribunal has decided this issue only on Ganpati reform, not on merits. And with the liberty given that if review is allowed by the Supreme Court, please come back.
Therefore, we'll tag it,
The
we'll tag it.
request is because ultimately even my lords tag
We've
it.
got other matters pending.
No,
we'll
no,
tag it.
I'm not saying no. It's not that they are remediless. Tribunal says if the review is allowed, please come back to us. That's liberty.
We'll keep it here.
On merits, ultimately.
We don't want to follow a different course of action because this will affect other matters which are pending. So we should notice and chat.
Have dismissed the numerous matters.
We'll keep
before,
it. We'll keep it here, yes.
Well, ultimately, because my lord will be sending back to the tribunal.
All right.
Very good.
My lord, I'm only praying for a Passover, my lord.
Tell us what the matter is about. You argue.
My lord, the learned Solicitor General is leading us, my lord.
But for us, you are the Solicitor General at this moment. Tell us what the matter is about.
My lord.
The matter is about.
Argue for 5 minutes, then we'll
My
look into.
Mr. Solicitor, just one second. Let a junior argue the matter. Please sit by his side. Yes. Tell us what the matter is about.
My lord, the matter is about non-filing of affidavit of admission denial along with the written statement, my lord. The impugned
So
order
the High Court has relied on the Delhi High Court rules,
my lord.
according to which the list of documents has to be filed at a much anterior stage. It says affidavit of without an affidavit of admission and denial, right? So the written statement, it says, will not be taken on the record without an affidavit of admission and denial.
My lord,
That's the Delhi High Court rule.
that's the Delhi High Court.
That's why you have been non-suited. Now, what is your answer to that?
My lord, CPC Order 11, Rule 4, my lords.
Yes.
It is very clear, my lords. The affidavit of admission denial has to be filed after interrogation and investigation of the documents have been done, my lords.
And what does the Commercial Courts Act say?
Commercial Court Act, my lords. This is the Order 11, Rule 4 as amended by the Commercial Court Act, my lords.
Right, but which is the provision of the Commercial Courts Act?
My lord, the Commercial Court Act amends CPC.
Which is the provision of the Commercial Courts Act which you are relying upon?
Page 15, my lords, of the impugned order.
Solicitor said 15, so you said 15. Hello, the issue notice. Oh, right. Issue notice. We have heard Mr. What's your name?
Avinash Agarwal.
We have heard Mr. Tushar Mehta and Solicitor General with Mr. Avinash Agarwal. Issue notice. Turnable on. Till so and so further proceedings. Should we stay the proceedings? Further proceedings in the
The real question would be, the High Court says
the rules will prevail over
the
the act, over the CPC.
There are 22.
Returnable on so and so. Pending till the next date of listing, there shall be a stay of further proceedings in the suit. Don't you know? Here what happened was that they didn't file. $123 will issue notice on bill.
Advocate underwent some ISIS.
Item 14.
Lord, I beg to appear on behalf of the petitioner. My lord, firstly, my lord,
The
Honorable High
issue
Court.
is as to whether after the appointment of the arbitrator by the Calcutta High Court,
Yes.
the Tripura Commercial Court could have refused to refer the matter to arbitration. And I think the High Court is
My simple answer to this, my lord,
the High Court had appointed an arbitrator.
without examining and considering the records that were lying before the arbitrator, which is completely a separate set of pleadings, my lord, before the arbitrator. My claim before the commercial court is completely independent of the dealership
All this
agreement.
can be argued before the arbitrator. Why should we entertain it at this
But
stage?
the Section 11 application on the basis of which the arbitrator has been appointed by the Calcutta High Court, my lord, is
No,
based
overall,
on arbitration
overall, the
agreement.
the long and short of the story is that it can be sent to the arbitral tribunal. Why should we?
My lord, my set of pleadings in the commercials, it is completely independent of the dealership agreement. I am not at all governed by the dealership agreement. There is a basic misunderstanding on the part of the court, my lord. Secondly, my lord, without considering and examining the records lying before the arbitrator at Calcutta, my lord, the court could not have at paragraph 18, my lord. If your lordship kindly turns to page 15, paragraph 16.
Ultimately, what has the High Court done? The High Court has said that let the commercial remand order and saying that the commercial court should consider this.
Yes. Man, there could be parallel proceedings, man, without looking into what was there before the arbitrator. The set of claims that were completely different, and my claim before the is a money suit, my lord. It's a simple money suit. It's a commercial claim. It is not a case of claim and a counterclaim. My set of facts are completely independent of the dealership agreement. Paragraph 10 of the plaint, my lord, that is a different set of facts. Secondly, my lord, the High Court had interfered with
Who are
order.
you? Who are you actually? Who are you in the sense? Who is your client?
My client is the instant petitioner, my lord, who has filed the commercial court in the Tripura High Court, in the commercial division court in Tripura.
You are the dealer.
Yes.
You are the dealer.
No. Yes, I am a dealer. I am a dealer, but not eminently from.
Maybe you are saying that your claim is independent of the dealership agreement.
Yes.
Your status arises as a dealer under the dealership agreement.
No, that
the High
dealership
Court says, please consider our order. It directs the commercial court to consider
from
their order, appointing an arbitrator.
Yes. Well, the arbitration agreement, which is between me and the dealer, maybe, my lord, it's an alleged document, is not at all a document which is with my custody. I have specifically stated in my plaint that I have never seen, this document has never seen the light of the day. In that event of the matter, my set of pleadings in the commercial court would have been in the light of the dealership agreement.
All this,
but
all this has to be looked at by the arbitrator. All this.
Arbitrator is deciding on the dealership agreement. That is for the respondent. That is that is the claim of the respondent against me. My claim against the respondent is completely different, and my suit is a prior.
You heard your point. No, it has to be before the arbitral tribunal. But anyway, we are not directing it has to be sent to the arbitral tribunal. The High Court has merely remanded the matter, directing the Tripura Commercial Court to consider its order, Calcutta High Court order appointing an arbitrator. That's all.
But this is where I join my issue, my lord. Just one day.
I heard you now. I think we've made access clear.
To say, my lord, that the Calcutta.
Lordship, in item 15, it is in my humble submission that the Honorable High Court has committed grave error in saying that the minor dispute was transferred to respondent number 1 because it was transferred without following the provisions of law, and according to me,
But
it is
before that, you have to answer why we should condone the delay of 170 days in filing the SLP.
My Lordship, because the petitioner was not knowing that there is a limitation in filing the SLP in the Supreme Court, and the advocate who was dealing with the matter in High Court
on the ground of delay. Yes, thank you. Item 16.
My Lordship, may kindly consider as soon as we got the matter, we got it filed. My Lordship, may kindly consider because the petitioners are also very not very poor. My Lordship,
they have been in possession of the mine for the last 50 years.
But my Lordship, that transfer was illegal. My Lordship, that was
not a case for injunction. The High Court says that somebody who's in possession of a mine for 50 years, they can't be now injuncted like this. So, though we are dismissing, we can say this. We can even say this. Though there's a delay of 170 days in filing the special petition, we have also examined the correctness of the impugned order on merits and find no reason to interfere with the order. The special petition is accordingly dismissed both on the ground of delay and on merits.
My Lordship, one last.
That's better. So that item 16.
Blacklisted issuing any show cause notice and contrary to the terms of the tender itself, if my draw your lordship's attention to page 98.
The cancellation may be. Senior counsel appearing on behalf of the petitioner submits that the petitioner was blacklisted for a period of 3 years from participating in the works of the contracts of the municipal corporation without a notice to show cause being issued.
Not.
Issue notice confined to the above aspect,
Lordship.
returnable on.
Lord, we are only requesting for a stay, my Lord, because I won't be in a position to participate in any of the options, my Lord.
We'll make a short notice.
Lordship.
Oh, I see.
Lordship.
It's a due process.
Obliged.
So 17 number of petitions have been disposed of by the High Court. All the matters are not listed today. They pray for a one week time.
But there's a 174 delay, 174-day delay here.
No, as far as the first matter is concerned, there is 74. As per my-
174-day delay.
In other matters, it is not there, madam. In other.
174.
Yes, but in other matters, the delay is not too much, madam. Kindly see, madam. In some matters.
17. How many matters are there on 17?
In total, there are 8 matters, 7 matters, madam. All the matters are not listed today, madam. It will be taken after a week, madam.
You can get your other matters. We'll dismiss this on the ground of delay.
Kindly see, my lord.
How can the state keep on saying that, look, there are other matters where there is no delay, therefore condone?
I'm not saying, I'm not saying, madam. Kindly take up all the matters together, madam, because there are delay part is concerned.
We will keep those other matters. We'll dismiss this on limitation.
Madam, kindly take up.
Limitation applies equally to everybody, and I think state governments in India now must be absolutely alert. And merely because it is a state, the government officers cannot just sit
As per my
and
report,
allow.
74, my lord.
And it's serial number 37, there's 74 days delay. We'll look at that matter independently. When it reaches, we'll take it up. This one we will dismiss on the ground of limitation.
My lord, I'm just saying that we'll take, because on the technical ground, kindly see, my lord. Technical ground, my lord, they have to more than 3 or 4 crore rupees, my lord, kindly see. They have to pay more than 3 or 4 crore rupees, my lord, kindly see.
7 reaches. We'll see what the merits.
All the matters are not listed today, madam. If I'm saying, if you've taken after a week, madam, all the matters, madam.
How many are there?
In total, there are 8 matters, madam. Only 3 or.
Like, give the number to the numbers.
Yes,
to the
I will put the numbers.
List together with so and so.
On Friday, madam, next Friday. In the meantime, if there is defect, I will put the defect all them.
Item 18.
But it's on Friday, madam.
Next Friday.
This is a really piquant and unjust situation where I can't appoint an arbitrator. The matter is under litigation. Their appeal has been remanded by this honorable court to the High Court because it was earlier dismissed as non-maintainable. So the arbitration award has been set aside as being perverse at my instance.
The arbitration award was set aside by the single judge.
Section 34 judge.
I think Justice Dhanuka's judgment.
That's right.
We had dealt with this.
Justice Baldotta's judgment.
Justice Baldotta's judgment. There was a similar case which just came a few days back where there was the division bench set aside Justice Baldotta's award on the
ground of perversity.
On the ground. What happened in the single judge?
No, thereafter, after the award was set aside on the ground of perversity, they filed a Section 37 application, which was dismissed as non-maintainable. Then they came to this honorable court. This honorable court found the appeal was maintainable and therefore remanded it back
to the division bench.
To the division bench, and that matter is still pending, though we have made requests, and this honorable court had also directed expedition. That matter is still pending. When therefore this matter is still pending litigation, and the situation is that a perverse award against me has been set aside, behind my back, 2018, they enter into a development agreement with respondent number 3. This is not disclosed. It is disclosed for the first time in 2023, where when I discover by chance that a huge construction is being put up, I move an application.
Mr. Ramchandran, what is the investment by your client?
The investment by my clients is 22 lakhs in a matter of 1.5 crore at that time. The amount should not matter at all, my lords. That was the initial payment.
If a construction has taken place, and now you have invested about 22 lakhs,
he has paid 8 lakhs, bullets. The respondent number 3 has paid 8 lakhs. It can't go by the figures.
Seems to have also been impressed by the fact that now impeding the development, the tenants on the property who are waiting for being rehabilitated.
With respect, bullets. With respect, those tenants who are part of the original bungalow, it's not some resettlement scheme. It is a bungalow which is being demolished and a 15-story structure is being put up.
The award against you in the arbitration right? The award in the arbitration. What is the actual award in the arbitration which was set aside?
The award was that I'm not entitled to specific performance and I'm not entitled to damages, both of which have been set aside because the award has been held to be perverse. So the matter is at large, and I file a fresh Section 11 application for the reason now that this third party has come. This third party seeks to get impleaded in that appeal. And I can't appoint a Section 11. Award was that my claim was dismissed. My claim was against his reneging on the 2005.
So your claim
MOU.
for essentially for specific performance or
Lordship.
implementation of the MOU, that was rejected by the arbitrator. The single judge set aside the award and just set aside the award simpliciter.
Simpliciter on the ground of perversity, but set it aside.
Right.
Therefore, fresh arbitration has to start. In any case, a fresh arbitration has to start. Immediately after the appeal was dismissed by the Bombay High Court, I filed a Section 11 application for fresh appointment of an arbitrator.
The appeal is by the other side, of course.
The appeal by the other side. When that appeal was dismissed, I filed a Section 11 application. But then this honorable court remanded the matter back to the High Court. So logically,
even assuming that ultimately in the appeal, the award is affirmed, you still have recourse to a fresh Section 11.
and that is not being allowed by the impugned judgment. That is what is not being
They have
allowed.
created third-party rights in the meantime.
Lordships, and they have created third-party rights. And well, a fault is being found with me.
We'll have to consider this because you have been non-suited even on your
Lordship,
Section
please.
11. Section 9 or something, we may or may not be with you.
Section 9 minutes, my request is this. If behind my back, this agreement is entered into and not disclosed to the court,
You're also a very big builder in Mumbai.
Lordship, please.
There's nothing behind your back. You see the whole construction coming up, and you said a big building is
I
coming back.
happen
Nothing
to
is behind your back.
see it because I was passing that way. I'm not traveling on all the roads of Bombay every day. I'm not traveling on all the roads of Bombay.
This is not by this
On Section 9, if your lordships are issuing notice,
11, perhaps you have a point that at least your remedy under 11 can be kept open. Depending upon the outcome of that appeal. Perhaps we'll see.
On Section 9, my only limited prayer is this, as your lordships issue notice, let them not create third-party rights in favor of buyers. Let them not create.
We are issuing notice. We'll make a short notice. We don't want to issue an interim order without hearing them. Serve dusty and come. We'll just rise, members of the bar will rise because our distinguished colleagues from Brazil have to go around the court and look at the facility. We just rise for 2 minutes. And
before the learned visitor rises with your lordships, I thought an anecdote, seeing your lordships encouraging a junior a few matters back. 48 years ago, in court number 2, Senior Justice Chandrachud was the presiding judge, and a 2-month-old lawyer, namely yours truly, was appearing before him, shaking with nervousness. And Senior Justice Chandrachud looked at the appearance slip and said, "Yes, Mr. Ramachandran," which gave me such confidence that I was able to argue a useless matter for 5 or 10 minutes. So I was reminded of that day, Milord. Sorry, I'm not sure.
Thank you, Mr. Ramsar.
But can I request, Milord, for Dusty in addition, Milord, so that it comes in 2 weeks,
I
Milord?
just told the court master it will be served Dusty and after 2 weeks.
And no third party rights, Milord, in the
That,
meantime.
that's why we're giving you 2 weeks. Thank you.
Lordship, please.
Now, Parmeshwar, which are the states which have not implemented our judgment?
I just circulated a note here. I have a note, minutes. I have got a detailed note, minutes.
You have the note here?
Yes, yes. What is this kind of take the note?
Mr. Solicitor, that is the updated position you have now of who has.
Yes, I have the updated position till yesterday night. Then it's till yesterday night we were served affidavits and compliance. But I just wanted to bring to your lordship notice, this is the 6th or 7th time your lordships are asking them to pay up allowances and pay ballots. If your lordships kindly see the major defaulters, let me just point out from page 6 onwards. Well, that's a number of high courts have deducted TDS on allowances, my lord. So that issue I'll come to. But your lordships,
because allowances, you can't deduct TDS.
It is at all protected under section 192 and section 1014 of the Income Tax Act completely, because it is for money spent that allowances are paid. So there's no question of TDS, but I'll come to that a little later. If your lordships kindly see from page 6, Allahabad. Page 6 minutes. So lordship sees so far as Allahabad is concerned, my lords, there is more or less compliance. I shouldn't take. I think there are minor difficulties which will get ironed out, my lords. So far as Andhra Pradesh is concerned, there is substantial non-compliance. I have marked
substantial
non-compliance. Your lordship sees the last 2 columns. So far as payment of revised allowances are concerned, and payment of arrears of allowances, my lords, most judicial officers have not received it. Most judicial officers haven't received.
Fixed my loss, we just for payment of arrears.
Possibly, I just wanted to bring to your lordship's attention. The 7th time your lordships are extending time. Repeatedly, your lordship have recounted all those orders in the first 3 parts of my notice. At best, my lords, August 15. There are states which have moved IAS asking for 6 months, 2 years. Orissa on its own.
15th August. 15th August.
15th August. All states, my lords.
The note has been submitted by Mr. K. Parmeshwar, then the mic is curate, indicating the status of compliance with the orders passed by this court on.
Well, that's 3 orders, 27/7/2022,
27 July 2022
To
30 July 2023.
19th May 23 and 4th January 24.
19 May 2023
And 4th January 24.
Then there's 23rd November also, no?
That is only for extension, my lords. Your lordships again. For the substantial order, your lordships.
And 4th January 2024. Full stop. Those seven opportunities, right, have been granted by this court to the states to comply. It appears that full compliance has not been effected, and several states are in default. Full stop. The note highlights the states in default, and we will deal with them. Full stop. They are dealt with CRETIM, Andhra Pradesh, the Learned Standing Council, Standing Council. Standing Council. Ms. Prerna Singh, appearing for the state of Andhra Pradesh, states that she has instructions to the effect that the payments which were to be made to the judicial officers have been made.
Whatever could be uploaded has been made.
Whatever could be uploaded.
Portal. There is a portal for the uploading of bills of arrears, which is the main, if my lords will see the last column, that is the main non-compliance that has been attributed to us.
Ms. Prerna Singh, Learned Standing Council for the state of Andhra Pradesh, Learned Council for the state of Andhra Pradesh states that the portal through which bills were to be uploaded that payments have been made to the extent to which bills were uploaded on the portal, on the web portal, which was opened for that purpose. Full stop. Should we say, Mr. Parmeshwar, that this may be verified?
There's clearly non-compliance because judicial officers spoke to me yesterday night. Number of judicial, the All India Judges Association is also here, my lords. There is no doubt, my lords, most states have been lackadaisical.
All right. We will say that on the other hand, both the amicus curiae and and the All India Judges Association, which is represented in these proceedings, have categorically stated that that full compliance has not been effected. Full stop. We direct that a meeting be held by Monday between the Registrar General of the High Court of Andhra Pradesh, the Chief Secretary.
Would your lordship then direct that committee to meet? Your lordships had institutionalized it, and that committee, all of them, all the relevant people are part of the committee.
Be convened by the committee appointed by this court in its order dated
4th January 24.
4th January 2024.
SCDJ.
What do we call it?
CSCDJ.
The CSCDJ. Within preferably on Tuesday, we say to have a little time. Preferably on Tuesday next, so that in case compliance is still to be effected, it is completed no later than by 15 August 2015. Full stop. A compliance affidavit shall be first shared with the CSCDJ and thereafter filed before this court, indicating compliance, failing which this court will be constrained to adopt contempt proceeding against the officers of the state if full compliance has not been effected.
Then Bombay, my lords. So lordship sees Bombay at page 8, my lords. Most of it is in substantial compliance, except for the part so far as TDS is concerned. On TDS, your lordships will pass an omnibus order on all high courts, my lords. Would your lordships only see, this is unfortunately, my lords, your lordships will see, if your lordships, the second last column, what they've been doing is many state governments have again tinkered with your lordship's order on allowances. After your lordship's order, there's no question of the state governments now saying that this is not permissible under our rules. We will not allow it. Mobile handsets can't be. Your lordships, remember during the hearing also this question on mobile handsets,
that will deal with separately.
Furniture, ACs. So an omnibus order on the count that there's no question of now deviation from your lordship's.
That will deal with.
So far as Bombay is concerned, only this, because they have now said we'll take a call on mobile handsets and AC and furniture.
That we will.
Otherwise, there has been substantial compliance so far as Bombay is concerned. They have taken effective steps.
Which are the states which are not compliant?
Calcutta.
Calcutta.
West Bengal has moved an IA for extension of time, my lords.
We'll give you a time till 15th of August to comply by 15th of August.
I'm only requesting some more time, because 15th of August, because I don't want to come back, seek further time.
It has to be because 7 opportunities are being granted to us. All states have paid. I mean, how can West Bengal say we will not? Then you say that, look, then you can sit at home, will not take any work from judicial officers. They are all working there.
May I say this? It's only pertaining to arrears, because rest of the things have been implemented pertaining to the arrears.
Telangana state, my
That we
lord.
have not complied, because in the amicus report, it says partially complied.
How much have you paid?
They will not, none of the states are very smart. None of them will say how many judicial officers are there. They will say we have complied.
Because once we
No
come
details
clear,
of this.
shall come clear on this, because by filing
State of-
everything follows. Because
I just for giving specific. May I just
State of West Bengal, there has been non-compliance by the state of West Bengal with the orders of this court. Full stop. The time has been 1 year's time is sought for effecting compliance, which is unreasonable. Full stop. We grant time for full compliance till 15 August 2024. No, till we keep the matter for reporting compliance on 20 August, we'll keep the matter. We extend time for compliance until 20 August 2024. Full stop. The proceeding shall be listed on 23 August 2024, on which date both the Chief Secretary and the Finance Secretary for the state of West Bengal shall remain present before this court with affidavits indicating compliance.
All states, just bring to your lordship's notice.
Just allow me.
All state government and union government wanted with the 116, that was 7th pay commission. We are on the threshold of the next pay commission 2026, and yet our judicial officers after 8 years, 9 years have been received. It's not as if it's a separate case for judicial officers. Most of these recommendations are at par with state government and union officers.
We are constrained to pass the above order. We are usually circumspect in directing the personal presence of the officers of the state. Full stop. However, this is a situation where the officers, the bureaucracy has received the revision of their pay scales and other allowances with effect from 1 January 2016. Full stop. Judicial officers are yet to receive the revision, the revised pay scales and allowances. So the arrears which are due to them in terms of the SNJPC, so 8 years have elapsed. Full stop. Despite, as we have already noted, despite sufficient opportunities, there has been non-compliance. Full stop. It is in this backdrop that we have been compelled to pass the above order. So then,
Instead of
I'll just take.
bureaucracy, your lordships may consider administrative officers in the executive.
bureaucracy, administrative officers in the executive.
But it's a better, but that's
Better.
Let's take the Manoj comment. Manoj, just one thing, Manoj may not say that state of West Bengal has not complied. Manoj may kindly say partially complied, as the amicus has stated, because it seems that we have.
But you have not told us how much you have paid. You tell us how much you have paid. Then you would have recovered.
I'll come back on this and just.
Anyway, you now you think all right. Which is the next one now?
Just only one thing, if just in case we are not complying by 28th, then Manoj may require the presence of.
Now they have to remain present with an affidavit of compliance. Otherwise, we'll send them marching from here. Yes.
Plus, Chhattisgarh also concern is the allowances, fellas. But if your lordship, 1 minute, tax, my God said there will be an
Tax will pass a separate order.
Again, the same thing in Chhattisgarh also. They will say we are considering whether we should grant those allowances. I don't understand those DOs. With all due respect, fellas, after there is a Supreme Court judgment, the subject matter of all those DOs
mentions the Supreme Court judgment of 4th January 24, and then says we will now consider whether we must grant those allowances.
Where is that in your note?
Your Lordships kindly see page 10, Chhattisgarh Millets. Your Lordships will see committee is considering upon the mode of payment of concurrent charge allowance. State has issued geo-dated so and so sanctioning increments on acquiring higher qualification, but no date has been mentioned. All that is clear in your Lordship's judgment. There's no question of now saying that we will deviate from your Lordship's judgment. And your Lordship will see this.
State of Chhattisgarh, comma, the geo issued by the state indicates that the committee is considering the mode of payment of the concurrent charges allowance, correct? The concurrent charges allowance. The state has issued a geo sanctioning the increments on acquiring higher education qualification, but no date has been mentioned for effecting compliance.
And out of 20, only 11 have been sanctioned.
And full stop. Out of 20 allowances, only 11 allowances have been sanctioned. Full stop. The state, the conduct of the state of Chhattisgarh is plainly unacceptable. Full stop. Despite 7 opportunities, 7 is there also, no?
Everywhere.
Despite 7 opportunities, the judgments of this court have not been complied with. We direct the personal presence of the Chief Secretary and the Finance Secretary of the state of Chhattisgarh before this court on 20 August 2024. 20 August bola tha na?
23rd minutes.
23 August 2024, together with affidavits of compliance, failing which the court would be constrained to take recourse to the exercise of its contempt jurisdiction. All right, that's Chhattisgarh. Then a full compliance by the 23rd. Yes, and the Chief Secretary and Finance Secretary have to be personally present in this court on that day. Now we're not going to say that if you comply with, then you need not be present, because then they'll not comply with. Only if we now direct presence that they will comply with. We now know how to extract compliance with the order. Yes. We're not going to send them to jail if they comply, but they have to be present here and tell us that they have complied. Nothing doing now. Yes. Which is the next?
Delhi, Malats, page 12, no allowances, no arrears of allowances have been paid.
Delhi?
No allowances, no arrears of allowances. Last 2 column.
The NCTD, the government of NCTD has not complied with the orders passed by this court. Full stop. No case for extension has been made out. Full stop. We therefore direct full compliance with the orders of this court by 20 August 2023. The Chief Secretary and the Finance Secretary of the NCTD shall remain personally present before this court on 23 August 2023, together with affidavits of compliance for the purpose of reporting compliance, failing which the court would be constrained to take recourse to the exercise of its contempt jurisdiction. Then,
Assam, no compliance. They moved an IA for extension saying citing floods because there was
Assam,
no floods in the year of.
Filed an affidavit, Lordship. Lordship, we have issued the notification. So far as 14 heads are concerned, Lordship, we have issued the notification, the report, because it came later, Lordship. That was the only thing, Lordship. The time, Lordship, that is being taken, Lordship, is we are really, Lordship, now facing disaster.
the council appearing on behalf of the state of Assam states that a notification has now been issued for the payment of 14 allowances.
14 allowances.
Full stop.
Not 7, Lordship, 6. Lordship said
7.
There has to be full compliance with the orders of this court. Full stop. This court is not inclined to grant any further extension of time or exemption to the state. Full stop. The Chief Secretary and the Finance Secretary of this of the state of Assam shall remain personally present before this court on 23. So, ऊपर भी लिखा था ना 20th August and 23 August. Same order.
Lordship, our situation is a bit critical, Lordship. It's because of disaster situation.
These are people who are
Lordship has also-
working. These are people who are working in service.
Yes,
You have to pay
Lordship.
them now and just
Lordship,
get an
I-
opportunities. no?
Lordship, may I just submit, Lordship? Lordship has given time to the other state till 15th of August.
20th August we have given you. We have given you time until 20th of August, paid by 20th of August, and asked the Chief Secretary and Finance Secretary to be in court on the 23rd of August to report that they have complied. So that then we will we'll put an end to the matter.
That may be exempted, Lordship.
No,
We
no.
are in a genuine situation.
Then I don't know what will happen. Then
Different
there will be another application for extension. Once we say this, the money will come.
Lordship, we are in a peculiar disaster situation, Lordship. We are facing it, Lordship, in the state, Lordship, everyone is,
How much is the amount that you have to pay?
Lordship, I suppose it is more than 100 crores, Lordship, more than, it will be for a state like Northeast, and we are facing floods, Lordship. It is the third round of floods. It is the third round of
Ask
floods.
the government. Ask the government of India to pay you. They'll pay you from some other head. Yes.
Lordship,
Which is other.
Lordship, may our case, Lordship, may kindly consider.
No state.
The other states will not come out with this situation, Lordship. Our situation is a bit critical, Lordship.
We'll not do anything like
Lordship,
that.
may consider it on the next day, Lordship, on 23rd.
Still to remain, we'll see if.
Lordship, 23rd, if we don't show any progress, Lordship, kindly consider.
On the 23rd, if you are not able to pay, let the Chief Secretary and Finance Secretary come here and tell us why you can't pay. We'll consider your request. But they must remain personally present.
Lordship, that's what, Lordship, I was only requesting, Lordship. Kindly pass that order on 23rd, Lordship, if we don't do. Lordship, we are in a situation, Lordship. We are in a critical situation, Lordship.
Tell us from when did your
Otherwise, I would not have pressed it, Lordship.
Tell us when, from what date did you revise the pay scales of your administrative officers?
That we have complied, Lordship.
From which day?
So far as the administrative officers. So far as the SNJPC, Lordship, we have complied with everything, Lordship.
No.
That I can't offhand tell, Lordship, from which
When
date.
have they got
I'll take
revision?
instruction.
We'll tell you, 1st of January 2016.
Lordship, we have complied with every direction of the SNJPC, Lordship. We have complied with everything.
The point. We'll pay the state civil service officers. Judicial officers are not our.
Lordship, I
they're
am not making a
our-
legal argument, Lordship. I am not making a legal,
Not at all.
it's on
Now we
it's on a different criteria, Lordship. It's
Now
only
what
on
about, who else, Mr. Parmeshwar?
So far as Guwahati High Court is concerned, my lord, Arunachal, Nagaland and Mizoram, my lords, notifications are there, but release of funds is, according to the last affidavits, not comes. So your lordships may direct the same direction so far as Arunachal, Nagaland and Mizoram.
The same direction shall apply to the states of Arunachal, Nagaland and Mizoram. Then,
We are for the state of Nagaland. All the information has been collated, is scrutinized, is just pending with the finance department, your lordship. There has been compliance. We've accepted all the allowances, your lordship.
apply.
Kindly give us time, and your
we
lordship may
give
not,
it until 20th of August.
insofar as the presence of the chief secretary and the
We have
finance-
to now, we have to secure presence.
because there has been substantial compliance, it's
Yes.
just a dispersal of funds. your lordship.
The compliant come here, come visit Delhi once, yes.
My lords, Gujarat, my lords, I'm now told there is substantial compliance except TDS.
TDS, that
TDS
we'll
will
just
come.
pass an omnibus order.
Himachal Pradesh, my lords, the affidavit doesn't give us any information, fortunately. So far as,
What is the position in Himachal?
even the
State of Himachal Pradesh में ऐसा लिखिए, the Chief Secretary and Finance Secretary of the State of Himachal Pradesh shall file a joint affidavit indicating compliance. Full stop. Since as of date, who's appearing for the State of Himachal Pradesh? Where is he? Who's appearing for the state of Himachal Pradesh? Learned counsel for the state of Himachal Pradesh is absent when the case was taken up. Is taken up. Full stop. The Chief Secretary and Finance Secretary of the state of Himachal Pradesh shall personally remain present. Will be same order, huh? Let them come here. Yes. Then
Jammu, Kashmir and Ladakh, my lords, no money is paid.
Jammu and Kashmir and Ladakh, same order as
Complete non-compliance.
My lord, the paper for UT of Ladakh, may I assist your lords in case of the UT of Ladakh, my lord?
Yes.
My lord, in case of UT of Ladakh, all the funds are available with the two district judges, my lords, and the two district judges are the drawing and dispersing officers. The funds have been provided, my lords. The dispersal is with learned district judges, my lords. My lords, may I have my compliance affidavit?
Regards the Union Territory of Ladakh, Mr. Piyush Beriwal, right?
Yes, my lords.
Learned counsel states that the two district judges are drawing and disbursing officers, and the funds have been placed at their disposal.
Yes, my lords. My lords, we have also filed this via an affidavit, my lords.
All right. So Ladakh ke liye don't pass any order of presence.
Much obliged, my lords.
Jharkhand also same thing, there's no information on areas of allowances.
Jharkhand. Have payments been completed? Have you paid all the 20 allowances? Then same order for Jharkhand. Ask the Chief Secretary and Finance Secretary to remain present. Time until 20th. Yes. Then
Karnataka is not a concern, my lords. Karnataka is not concerned. Kerala, my lords, not paid. They have moved an application for extension. They have not.
Kerala, pay. That's all right. You ask the Chief Secretary and Finance Secretary to remain present. Kerala, the same order. Compliance by 20th, personal presence on the 23rd. 20th of August and personal presence on the 23rd. Yes.
Malas, Madhya Pradesh also same thing, Malas. SOP has been made by the committee, your lordships constituted, but no disbursement.
Madhya Pradesh is the same. Madhya Pradesh, same order. Then
Tamil Nadu, my lords, not a single paisa.
Tamil Nadu,
grave default.
Same order.
Manipur had a problem, my lords, they moved an IA over.
With respect to the pay and pension, everything has been paid. The allowances, they have been approved. The prospective payment of the allowances have started, and I have got a pay slip from the respective BDOs also. Because with respect to the areas of pay, that is the only problem that we have. Unless we were seeking a little bit of more time for
how much do you have to pay?
This is about 24 crores, and
the
state is running into some deficit.
Yeah,
So
pay, get it from the Union of India. Same order for Manipur. Yeah.
can it be a little
20th August, now 20th August. It's uniform for everybody. Yes.
Meghalaya also,
Meghalaya,
same thing.
same order. Meghalaya.
Let's Orissa, my lords.
You're from Meghalaya?
Instructions just now that the status was previous to end of financial year.
So 20th August. 20th August, ask the Chief Secretary.
My lords, I'll file an affidavit which has been.
If you have paid, if you have paid, mention the matter earlier and tell us we have paid, we will exempt our Chief Secretary. But otherwise, we have to be present.
Mention the matter.
But so far as Orissa is concerned, my lords, 6 allowances they decided not to do.
Orissa,
and so far as the arrears is concerned, they themselves decided that they will pay it over 6 or 7 installments.
Same order.
Lord, as far as the
Take order, 6 allowances have yet to be paid.
Lord, as far as state of Odisha is concerned, the resolution of the finance department has come in on the 16th of March 2024, and the law and the home department have submitted the proposal in the ensuing session for release of funds in the Odisha legislature. That's the instruction which I have.
Learned Council for the state of Orissa states that the
resolution of the finance department has been issued on 16/3/2024.
That the resolution of the finance department was issued on 16 March 24.
And the law and home department has submitted the proposal for making the budget provision in the ensuing.
And the law and home department have submitted proposals for ensuring payment.
The budget provision.
For making a budget provision in the ensuing budget session.
Ensuing Odisha.
20th August, we are keeping compliance and ask the Chief Secretary and Finance Secretary to remain present.
Very well. Very great.
Yes.
And so far as Patna is concerned, with it, I'm now told yesterday evening I received a note saying that they have started disbursal of all the allowances. But the last affidavit which was filed said that allowances have not been paid.
All right. Then yes. Then
Punjab and Haryana High Court, again, the committee filed an affidavit.
Bihar, as a Learned Council for the state of Bihar states that an amount of rupees 122 crores has been transferred to the Law and Judiciary Department, right? And and the payments are being made in full compliance with the order of this court. What's up? Then
Punjab and Haryana, allowances arrears have not been complied with, and allowances future payments are partial compliance. Your Lordship, see the last two columns.
So same order for State of Punjab, ऐसा लिख लीजिए. Same order, we'll say. Full compliance, we should.
There is an issue with respect to State of Punjab and Haryana. The matter is pending before the full bench of the High Court. The allowances is, that's why they were not released. The state has complied with it. Your Lordship may see the note as well. There's an SLP pending before this court, pursuant to which the High Court has held its hand and not released the and not granted this approval.
Which allowance? Which allowance?
So except for super
Other than
time,
that, we have been done, Your Lordship, for the State of Punjab. For the State of Punjab, we have done, Your Lordship. Only that matter remains pending before the High Court. Page 1168.
all right. State of Punjab के लिए ऐसा लिख लिया. Which where is page Punjab is
Page
20.
1168, Your Lordship.
That's in respect of, that's not allowances, that's only selecting time and super scale. That's litigated between the judicial officers, therefore that full bench I've
So
examined.
what about the allowances? Have you paid the allowances?
Your Lordship, we'll place that on record, Your Lordship.
Sorry?
We have released the allowances, 11th April 23, Your Lordship.
We pass the same order. If you have, come back to us, file an IA before the next date of listing. We will and give it to Mr. Parmeshwar. We'll verify it. We'll delete the requirement of the presence of your chief.
But to that effect, Your Lordship.
So you first ensure that the full payment is made. File an affidavit. Give it to Mr. Parmeshwar. Come here and mention it. We will exempt appearance. You know?
Whereas Rajasthan, same order as the others. No information has been provided to this court in the complex.
Rajasthan. All right. Anybody else?
But I'm sorry, my lord. I was just trying to say something, but I was not unmuted. Unmuted, my lord. For Delhi, my lord.
Yes, for Delhi.
Problem for Delhi. Yes, my lord. We are waiting for the approval of the central government because we have we can make payment only once the central government approves.
No, we are not concerned with that. You sort it out with the central government. We want payment to be made. Yes.
Look, in that Punjab and Haryana, the other order continues.
Central government has permission. This.
Haryana. It has high courts because the Haryana, the other orders continue because they have not paid up the allowances.
Haryana का same order will continue.
And Punjab is on.
Punjab का हमने order pass किया था.
Telangana state में लगा.
Rajasthan,
the central government has filed review petition.
Punjab and Haryana, we have passed the same order. Punjab, Haryana, the same order of personal presence.
Right.
Provided if they come back here and file an IA saying that we have paid, then you can tell us. We will. You can mention Parmeshwar that these states have been. We can come and mention so that.
Yeah. So that's so far as Rajasthan, Sikkim, Tripura, and Uttarakhand concerned. Rajasthan, Sikkim, and Tripura the same order. Allowances have not been paid.
Rajasthan, Sikkim, and Tripura same order. And
Telangana has complied. Uttarakhand the only issue is TDS.
All right.
Plus on TDS, I just one suggestion.
As for Sikkim, may I make one submission, my lord? May I request for a similar indulgence as the previous council? Once I file the updated status of allowances, may I make a request for exemption for appearance, as my lords have permitted the previous councils for other states? Because I'll get the updated status and ensure that the allowances are paid.
Let them be, yeah.
Yes,
let them hear.
Similar
Let them appear, yes.
Sorry. As far as TDS is concerned, would you also pass an omnibus order saying wherever the exemptions are under the Tax Act, so far as allowances are concerned, no TDS should be cut because there's no point in going allowances
we say,
one by one.
Wherever exemptions are wherever exemptions are available under the provisions of the Income Tax Act 1961, from the deduction of TDS on allowances, the state government shall ensure that no deduction of TDS is made.
And wherever deducted, my lord will give them time till September to return that because then this is complete deduction. It'll have to go back because this is 1 minute. The state government is deducted so that
wherever the state governments have wrongly deducted the TDS, they shall refund the amount to the judicial officers on or before 15 September 2024, with liberty reserved to them to pursue their claim before the department.
I have encapsulated with my note which I have circulated. I have put an appendix A where I have encapsulated under the Income Tax Act, which all allowances that are part of the SNJP are exempted under the Income Tax Act. So, my lords, if something like that can happen, and I've also annexed along with my note
the payment slips of the judicial.
All right, what we'll do is that we'll take up, we have covered the states, right? On the issue of TDS ka baad mein dekhte hain. We'll keep it on Monday. Just look at what she has said, the allowance exam.
My only fear was that.
Can you serve the central government council so that we can then deal with TDS on that? Just ask Mr. Venkatraman to remain present here on Monday. You can tell him what the issue is so that then we can clarify it.
Just housekeeping, sorry.
Yes.
So that all those contents in the IS can be disposed of unnecessarily.
For Telangana state, my lord, no complaints. For Telangana state.
Where are they?
Page 26 of my.
Yes, there are eight contempt petitions. Yes. Page 26 ko, serial numbers 1 to 6 IS are stand disposed of.
Similarly, my lord, those 8 orders dated 22, of them merge in those contempt petitions.
Telangana state, my lord. Telangana state.
57, there are a number of IAS and petitions for intervention increase prior to your lordship. Those also can.
All serial number 1 to 17? Serial number 1 to 17 का जो पेज 27 और 28 को है वो भी disposed.
Your lordships may mention one IA.
So what we'll do is
Your lordship on IA. Lordship. With your lordship's permission, Millers, may I?
Well, in the afternoon today, the NEET.
I'll just log in.
The matters on Monday, including NEET also we'll take up on Monday.
May I have your lordship's time for just half a minute? Can I have the attention of the court for just half a minute?
So we'll take up NEET tomorrow first on board, and then we'll proceed. Mr.
May I have your lordship's attention for a minute?
That's serial number.
38, my lord.
38, kal rakho. 38.
Lordship and lordship.
My lords, if 38 can be on Monday, my lords, we need take instruction and we'll place something on record also, my lords.
Mr. Ranjan Kumar, yesterday the solicitor was also saying that he will require a little time on Monday.
But the problem is this, not every day one order is being passed. Again, today has been passed.
Yes, that on record, my lord. Nothing worse has been passed, my lord.
What is being happening is, my lord, as I mentioned yesterday, not about what happened. Then on 9th July, they said, no, that order is withdrawn. Then on 10th again, yes.
Can we take it up on Monday?
Officers be so heartless. She's charged of 2 and 2 only. Can you take a woman to the police station in the night? Jealous. Okay, come to this. Baby of 2.5.